then the court may further examine it. Now I have put on the last session, I have put two questions. Suppose one is a legislation struck down being violative of distribution of power. Other is a legislation struck down being a violative of Charter of Rights. What are the effects of these two issues? If a particular legislation has been struck down being a violative of power of distribution of power, that is, that legislative body which has passed the impugned legislation has no competence to legislate on that matter. So that's why the court has struck down that. And the second part is where the court has struck down the legislation on the ground that it violates the Charter of Rights. Have you prepared the answer or not? Anybody? It's a long gap. All right, I'll just explain it. Now, in case a legislation has been passed by the provincial legislature, and the court finally held that no, I'm just discussing with you with an example. Suppose the Ontario Legislative Assembly passed a particular legislation, that is say A. It was challenged on the ground that this province has no competence to legislate this legislation impugned A. It was struck down by the court and declared unconstitutional. Now, whether a province can reenact this law again or not, the answer is no. Have you followed it? Very simple. If suppose Ontario leave rules or act has been passed by the Ontario Legislative Assembly, challenged before the Supreme Court of Canada on the ground that Ontario Legislative Assembly has no competence to pass this law. And finally, this law is declared unconstitutional by the Supreme Court of Canada. Whether Ontario Legislative Assembly is competent to legislate again on the same matter or not, the answer is emphatic no. Why? Because while interpreting the Constitution and distribution of power, the court has categorically held that it is not within the legislative competence of this provincial legislative assembly to make the law on this particular matter. Right? Now, there is another issue. Suppose the federal parliament passed a law, it is again challenged that it is not within the competence of federal parliament. Again, Supreme Court of Canada, on the ground that the federal parliament has no legislative competence to legislate this legislation A, as it does not fall within its ambit section 91, and declared it as unconstitutional. So now this is no more a law. Same principle will apply. The federal parliament now cannot reenact this law on the same subject because the competent court of law, the constitutional court, has categorically, I'm sorry, I'm not using a wrong word. the constitutional code. It is not a constitutional code. We'll discuss later on. We have discussed in detail about the status of Supreme Court of Canada. Now, this Supreme Court of Canada has held that this power of legislation on this legislation A is not within the competence of federal parliament, and hence this law is unconstitutional because it has been passed beyond the competence, as this issue or the matter on which this legislation has been passed by the federal parliament is not a matter which is described under section 91. So this law has been declared unconstitutional, and finally we can say on this particular matter the federal parliament has no competence to re-legislate on that. Right? Now you may say this is the third situation. Now court says federal parliament has no competence to legislate on this subject matter A. But why? It says under section 92, it is the prerogative and competence within the competence of provincial legislative assembly. So meaning thereby, now the federal parliament cannot reenact that law, but the provincial legislature can enact a law even though the law passed by the parliament has been struck down being unconstitutional. Why? Because it is in violation of the distribution of power, and the provincial legislative assembly is competent to legislate, then the provincial legislature may enact that law, which has already been struck down by the Supreme Court of Canada on the ground that the federal parliament has no competence, right? Similarly, in case where the provincial legislative assembly's legislation has been struck down on the ground that it falls within the purview and ambit of parliament, then the federal parliament can reenact that legislation even though the provincial legislative assembly has passed a law which has been struck down by the court, but still because of the distribution of power and under section 91, federal parliament is competent, so the federal parliament may enact a law which has already been struck down on the ground of competence of the provincial legislative assembly. Now, the first situation where provincial legislative action or federal parliament legislation have been struck down, but the court is not describing it that it falls within the provincial or legislative assembly. It is not clear. Then amendment to the constitution is required. Only after the amendment to the constitution and insertion of that matter within the competence of the federal or the provincial legislature will enable the legislative body to legislate. Otherwise, those legislative bodies have no authority to legislate. Right? Now there is another situation. Suppose the legislation has been struck down on the ground that it violates Charter of Rights. Suppose this is the provincial legislation. Provincial legislation has been struck down by the court on the ground that it violates Charter of Rights. Either of the rights described under the Charter of Rights or all, whatever it may be. But in a sense, the legislation violates the Charter of Rights, and it has been struck down being violative of the principles of Constitution, being the rights available to the citizens under the Charter of Rights, under the Constitution Act 1982, and struck down that legislation. Whether the provincial or the federal parliament can legislate, re-legislate or re-enact such a law? The answer is emphatic no. both the provincial as well as the federal parliament has no authority and competence under law to reenact that law because it is in violation of Charter of Rights, be it a provincial legislation or a federal legislation. It hardly makes any difference. Because it is in violation of the Charter of Rights, so either of the authorities have no right or authority to re-legislate unless and until Section 33 is invoked, that statute is passed, and ultimately the Charter of Rights have been given go by, and then the legislation may be passed. But in normal parlance, we can say if a legislation passed by either of the legislative bodies, struck down by the court on the ground that it violates Charter of Rights, then it cannot be re-elected except by another process, right? So this is all about the priority and the consequences and the ground of challenge by way of judicial review. But now the main part of the judicial review is the tools or techniques or the principles on which the judicial review has to be conducted on these two grounds while examining the validity of a legislation. And the first and the foremost is the matter. Section 91, Section 92 provides the matters which are within the competence of. Section 91 says the federal parliament can legislate on all the matters which are described under Section 91. Section 92 says all the provincial legislative assemblies have the competence to legislate on all the matters which are provided under Section 92. Now, so if there is a challenge, the first duty of the court is to determine the matter. Suppose a provincial legislation, the court has to examine whether this matter on which the legislation has been passed falls within either of the categories of matters under Section 92 or not. So, plain and simple formula that the matter on which the legislation has been passed, whether that matter falls within Section 92 matters or not. If the matters listed under Section 92 clearly prescribe that yes, the provincial legislative assembly can pass the law on the matter provided under Section 92, and this matter on which this impugned legislation has been passed is duly prescribed under Section 92, we can say that this legislation is within the competence. Now, take an example, insurance. You must be aware that this is a provincial subject. I am just using the word because you are acclimatized with the Indian context. Otherwise, it is specifically stated a matter listed under Section 92. Insurance is a matter which is listed under Section 92. So if a legislation has been passed by the provincial legislative assembly of either of the provinces on insurance matter, we can say the matter is duly covered under Section 92 and the provincial legislative assembly is duly competent to legislate on the matter of insurance. Now, there is another matter, suppose banking. A legislation has been passed by the federal parliament on banking. Section 91 laid down a matter relating to banking. The federal parliament is competent to legislate. So a legislation has been passed on the matter pertaining to banking. It has been challenged. The first thing to be examined at the initial stage or by the court on the basis of distribution of power, whether this matter of banking falls within the matters listed under Section 91 or not. It has been found that yes, this matter is listed in the matters provided under Section 91. So the legislation passed by the federal parliament is within its competence and is a valid legislation, right? Up to this extent, it's very simple. Find out the matter on which the legislation has been passed, find out whether this matter is listed in section 91 or 92 and determine. This is very simple. But where there is a replica, overlapping, then how can you determine? Suppose a legislation has been passed by the Provincial Legislative Assembly pertaining to insurance, but it is also touching the banking law. Now we have to determine what is the real intent of this legislation. That is called the principle of pith and substance. So we have to find out what is the pith and substance of this legislation. If we found that the pith and substance, that substantially the law is pertaining to insurance, we can say this Provincial Legislative Assembly is competent. And if we found after examining its pith and substance of the legislation that predominantly it is pertaining to banking, we can say this law is not within the competence of Provincial Legislative Assembly. So we will discuss tomorrow in detail regarding the pith and substance and other tools and techniques where the principle of judicial review is applicable for examining and determining the validity and constitutional validity of a particular legislation. Thank you very much. Have a good day.
Thank you, sir.
Thank you, sir.
Thank you.
Tomorrow we will meet at 8 o'clock, right?
So grateful, sir. Thank you.
Okay.